here's what I'm thinking. Okay, I know some veterans. I have a friend that's a veteran, and you did a training kind of we did an interview, but it was a training on some of these issues for veterans who are disabled. They're having health problems and they're not getting any help, and they don't even realize they're eligible or what to do. And sometimes it's related to the less than honorable discharge, which is, we've talked about that in another session too. But in going through this, can you give us kind of maybe just the bullet point steps? Mm-hmm. So they apply for disability. You can maybe help them find the paperwork. They do that themselves. And then suppose they get their rating or whatever, you could potentially step in and help them in what areas. And I'm starting out with the things that we expressed already, but you talked about you could potentially help them with that rating, maybe get it higher, but take it from there and tell us a little bit more about how an attorney can be helpful in this process.
Yeah, so bare bones, you have the application, like you said, the rating decision, and you can appeal for an increased rating, or you can appeal for service connection if you're denied. At any point after the rating decision is issued, an attorney can get involved. So if you get your rating decision back and you still want to go at it yourself and file a notice of disagreement, you can do that, obviously. But basically, at any point in the process, we can be, engaged in a case and be hired to help any veteran with their cases. So when you get a rating decision, you have to file a notice of disagreement within 1 year of receiving that decision. And there's a form that is associated with that. I'm not sure what number it is off the top of my head, but you submit that. The next thing you'll get is what's called a statement of the case. And that's essentially a rating decision. It's just formatted differently, and it's the next step. So they have to differentiate, between the two somehow, so you know where you are. At that point, you have 60 days to file what's called a Form 9. So that's easy because it's Form 9. You can find that. And then you can also submit any additional evidence you want to with that. That will take you to the Board of Veterans Appeals, where you can either have a hearing or you can opt not to have a hearing with a veterans law judge. So you can have them. Those are all conducted at the regional offices.
Okay.
In whatever state you're in. There's a few that have multiples, but generally speaking, they're at the state capitol, like in Alabama, it's in Montgomery, Mississippi, Jackson, so on and so forth. And they'll issue a decision, and they can either grant, deny, or remand your claim. So let's say they grant it, you can say, I'm happy, we're good to go, everything's done. If they deny it, you can either file a motion for reconsideration, or you can have 120 days to appeal it to the Court of Appeals for Veterans Claims. If they remand it, then it kind of turns it around, sends it back to the regional office for further development, whatever that might be. And then the regional office will issue what's called a supplemental statement of the case. Sometimes those are done before the board hearings. Like sometimes you'll get a statement of the case, you'll appeal it, and then you get a supplemental statement of the case, and then you get a hearing. It just kind of depends on how it goes. And so from there, it goes back up to the board, and then the whole system goes forward with that, whether you're granted or denied, and you can take that to the Court of Appeals for Veterans Claims.